Your spouse just got orders overseas, but your citizenship case is still crawling through USCIS. What if I told you that there is a legal fast track that can naturalize military spouses in months, sometimes weeks, if you choose the right program and paperwork? Miss one detail, and you could spend the entire deployment separated, footing two household bills while your application sits on hold. Hi, I'm Attorney Zaira Solano, founder of Solano Immigration Law Firms with 13 years practicing immigration law, and I'm also a military spouse. I get this question almost daily from my military families. Can my spouse really get citizenship faster because I'm in the military? The short answer is yes. But like everything in immigration law, the devil is in the details. So today, I'm going to walk you through exactly how expedited citizenship works for military spouses, what are the requirements that you need to meet, and some critical mistakes I see families make that can derail their entire application. Let me start by explaining that there are actually two separate programs available to military spouses. The first is Expedited Processing, which speeds up the timeline of your regular naturalization application. The second is Overseas Naturalization, which allows you to complete the entire citizenship process while living abroad with your service member spouse. These are not the same thing, and understanding the difference is crucial because the requirements are different and the benefits vary slightly. I've seen too many military families apply for the wrong program or miss out on benefits they're entitled to simply because they didn't understand these distinctions. But that's why you got me. The Expedited Processing Program is designed for situations where your active duty spouse is being stationed outside the United States. Instead of waiting the typical 8 to 12 months for your naturalization interview, USCIS can fast track your case. However, and this is important, expedited processing is discretionary. USCIS considers each case individually, and they don't grant expedited processing in every situation, even when you technically qualify. For expedited processing, you need to meet several specific requirements. First, you must be at least 18 years old and already be a lawful permanent resident with a valid green card. Your spouse must be a U.S. citizen serving in the military who is currently stationed abroad or has orders to be stationed abroad for at least 1 year. Here's where it gets specific. Your spouse's orders must actually allow you to accompany them overseas. Not all military assignments include provisions for family members, and USCIS will verify this with military records. You also need to be physically present in the United States at the time you take your naturalization oath, even though your spouse may already be overseas. The language and civics requirements still apply. You need to demonstrate basic English reading, writing, and speaking ability, plus show a general understanding of U.S. history and government. You'll also need to establish good moral character and show that you support the principles of the U.S. Constitution. One requirement that trips up many applicants is the plan to live abroad and return. You need to demonstrate that you intend to live overseas with your military spouse during their assignment and return to the United States when the assignment ends. This isn't just a checkbox. USCIS may ask for detailed documentation of your future plans. Overseas Naturalization is a completely different program that addresses one of the biggest challenges that military spouses face: the physical presence requirement. Normally, you need to be physically present in the United States for half of the required residency period before you naturalize. For most people, that means 18 months out of 3 years if you're married to a U.S. citizen, or 30 months out of 5 years in other cases. For military spouses stationed abroad, meeting this requirement can be impossible. That's where Overseas Naturalizations comes in. This program allows you to count time that you spent abroad with your military spouse towards your physical presence requirement as long as you meet the specific conditions. You must be married to someone in the armed forces who is stationed outside the United States, and your spouse's orders must permit you to accompany them. You need to be living together as a married couple. USCIS takes this very seriously and may investigate your living arrangements. You still need to have held your green card for the required period, 3 years if married to a citizen, 5 years otherwise. The key difference is the continuous residence calculation. Instead of needing to physically live in the United States for half of the residency period, you need to show continuous residence either in the US or abroad with your military spouse for up to 2.5 years. This calculation can be complex, and I always recommend having an attorney review your specific timeline. Let me address some requirements that cause the most common confusion and application denials. The good moral character requirement isn't just about having a clean criminal record, though that's certainly part of it and very important. USCIS looks at your entire history during the required residency period. This includes tax compliance, selective service registration, if required, and any immigration violations. I've seen cases denied because applicants didn't file their tax returns for years when they were living abroad, even though they weren't required to pay U.S. taxes. The IRS requirement and the immigration requirement are different. You need to stay compliant with both. If you've been living abroad and haven't been filing tax returns, address this before you apply for naturalization. The English language requirement also applies to military spouses with very limited exceptions. Some applicants assume that because they're getting expedited processing, the language requirement might be waived. That's not the case. You still need to take the English test unless you qualify for one of the specific age and residency exceptions that apply to all naturalization applicants. This is one of the most heartbreaking situations I deal with as an immigration attorney. If your spouse dies while on active duty or from a combat-related injury or disease, you may still be eligible for military spouse benefits. The law recognizes that surviving spouses should not be penalized for their spouse's ultimate sacrifice. These cases require additional documentation, including military records confirming the circumstances of your spouse's death. The application process is similar, but USCIS has specific procedures for posthumous benefits that your attorney needs to understand thoroughly. Military families often ask about their children's eligibility, and if your children are not U.S. citizens, they may qualify for overseas naturalization as part of your military family. The child must be under 18 years old, and their parents' military orders must allow the child to accompany them abroad. There's also a requirement that the U.S. citizen parent was physically present or living abroad as part of the military service for at least 5 years. This applies to biological children and children adopted by U.S. service members. One important point: children who automatically acquire citizenship through their parents don't need to go through naturalization. But if they don't automatically acquire citizenship, the overseas naturalization option can be very valuable for military families. I see the same mistakes repeatedly in military spouse naturalization cases. First, applicants fail to notify USCIS that they're requesting expedited processing. This isn't automatic. You need to specifically request it and provide documentation supporting your eligibility. Second, many applicants underestimate the documentation requirements. You need military orders, evidence of your living arrangements, tax records, and detailed travel records. Missing or incomplete documentation is one of the most common reasons for delays. Third, applicants sometimes apply too early or too late. The timing windows for these programs are specific, and applying outside these windows can result in denial or significant delays. That's why I always recommend having an immigration attorney calculate your earliest possible application date. Military spouse citizenship benefits are significant, but they're also complex. The interaction between military regulations, immigration law, and administrative procedures requires careful navigation. These programs exist because Congress and USCIS recognize the unique sacrifices military's family make, but they still require precise compliance with legal requirements. Getting expedited citizenship can mean the difference between being separated from your spouse during overseas assignments or being able to maintain your family unity while serving our country. For many military spouses, these programs provide a pathway to citizenship that wouldn't otherwise be available given the demands of military life. Today, we've covered the two main pathways for military spouses' citizenship: expedited processing for spouses whose service members are deploying overseas, and overseas naturalizations for those already living abroad. You now understand the specific eligibility requirements, the documentation you'll need, and the common pitfalls that can derail your application. But here's what every military family needs to know about right now. There's a brand new $15,000 immigration visa bond that's affecting military families in ways that most people don't understand. This bond requirement is creating serious financial pressure on military families who are already dealing with the cost of relocation and deployment. In my next video, the new $15,000 immigration visa bond, will you have to pay? I'm going to break down exactly who has to pay this bond, when it applies to military families, and most importantly, the legal strategies that you can use to avoid it or to get it reduced. This is critical information that could save your family thousands of dollars and prevent serious immigration complications that I'm seeing in my practice right now. If you're a military family navigating the immigration system, you cannot afford to miss this information. The bond requirements are changing how military families approach immigration planning, and the strategies I'll share could be the difference between a smooth process and a financial disaster. See you over there.